Welcome everyone to the South Australian Business Chamber's Rules of Work, what you need to know in 2026. I'm delighted to introduce you to Sophie Katsaros and Andrew Tulic, who have recently joined the Chamber as senior consultants. The Workplace Relations team, including Madeline Moss and Philip Howard, who are the consultants on the Business Advice Hotline, and our senior consultants, provides a tailored advice to help businesses manage risk and address workplace challenges. Both our senior consultants have extensive hands-on experience across key areas, including workplace relations, work health and safety, industrial relations and HR. Andrew joins us from the Australian Industry Group, where he was a senior advisor and associate. Prior to that, he was at K&K Legal. He brings a wealth of experience in representing employers in the Fair Work Commission and advising on matters including industrial relations, workers' compensation, work health and safety and HR. Sophie has worked in employment law for commercial firms for several years, and she has extensive experience providing commercial advice and representation on work health and safety, work discrimination and Fair Work Commission matters. So this is our standard disclaimer. Call our business advice hotline if you're a member, or contact our senior consultants for more detailed advice on any of the matters that we discussed today. We've been supported in providing these webinars by federal government funding and the Australian Chamber of Commerce and Industry. We've had major legislative change since 2022. Which has expanded regulation across bargaining, employment categories, payroll compliance and union rights. Businesses face increased compliance and complexity due to interaction with the Fair Work Act, modern awards, enterprise agreements, in addition to other changes in the business environment. Higher penalties and criminal wage theft provisions have significantly increased legal risk for employers. Workforce models relying on casuals, contractors or labour hire now face greater scrutiny. Understanding these reforms is critical for compliance, workforce planning and business productivity. We've got increased red, white and green tape and whatever other colour tape you want to provide. Compliance and the cost of defending claims, regardless of their veracity, has been increased by this type of legislation. So let's have a look at some of the more relevant matters. So you'll note most of these matters are now in operation. We'll take a deeper dive into some of them today. Since the introduction of the Closing the Loopholes and the Secure Jobs Better Pay Act, we've had reviews of these acts. The Secure Jobs Better Pay Act dealt with 4 areas: changing regulatory bodies, increasing wages and restoring collective bargaining, job security and gender equality, and a range of miscellaneous changes. It was reviewed and the report was made available in August 2025. And it found that while working reasonably well, there had not been enough time to identify what possible issues may arise from the Act. And there were a couple of really important recommendations that came out of it. One was they want another review in 2 or 3 years. So we do get another opportunity to make comment about how the Act is impacting on business. And so we would really appreciate feedback to enable us to do that on your behalf. And recommendation 17 of the review recommended that stakeholders should seek variations to modern awards to tailor the limitation on use of fixed-term contracts to their industry or occupation. So if there are issues using the restrictions in fixed-term contracts, please let us know, because this is something that we will need to either do something about or at the very least report on when we do the next review. Recommendation 18 was the Australian Government should undertake a short final period of consultation to identify targeted improvements to the limitation on fixed-term contracts to address issues which cannot be currently resolved through modern awards and make the limitation more readily applicable in practice. So there have been identified some significant issues with fixed-term contracts. The Closing the Loophole Act, there was two of them, 2023 and 24, made changes that came into effect any time between 2023 and 2025. And the acts increased the powers of the Fair Work Commission. It impacted casual employment. It changed the definition of employment. It made significant changes to bargaining agreements and restricted labour hire arrangements. It introduced road transport industry powers to the Fair Work Commission, as well as the ability to deal with disputes on unfair contracts for contractors. It introduced further workplace delegates' rights and provisions for employees impacted by domestic violence. So there were significant changes. One of the largest changes was one that businesses argued did not need to be made, which was changes to the casual status definition. If you've had any issues with that, please contact us. Employers now face a test considering the real substance, practical reality and true nature of a relationship rather than solely its contractual nature. There's a few other items that have been raised. One was a state act that has just come into effect, which is the Workplace Protections Personal Violence Act, and there is some information coming out in our next South Australian Business News regarding this act and the impact it will have on businesses. And Payday Super was another one that is just about to come into effect, and we've just had responses from our survey of business expectations finding that about 50% of respondents indicated they were not ready to some degree for this to come into effect on the 1st of July. There are some issues that are impacting employers. The Closing the Loopholes review was published on the draft was published on the 18th of May, and stakeholders have been invited to comment. And South Australian Business Chamber will be doing that through the Australian Chamber of Commerce and Industry. It states that many of the amendments enhance worker rights and are broadly operating as intended, but also acknowledging that a full assessment of several measures is not yet possible due to their recent commencement. So again, we're in a way we are reviewing too quickly. Importantly for employers, the report identifies that a number of reforms have increased regulatory complexity and compliance requirements. In particular, it observes that some amendments expand the volume and nature of employer obligations. Please tell us if that's something that's happening for you. Requiring businesses to actively manage new legal standards rather than rely on settled rules. Things are changing and changing far more rapidly. The introduction of new and expanded frameworks shift greater responsibility onto employers to interpret and operationalise legislative requirements in practice. And at a system level, certain changes increase the complexity by design, reflecting the policy intent to reshape the workplace rights and obligations. And the draft report notes that some measures, such as wage theft offence and increased civil penalties, to the underlying obligation to pay employees correctly, but instead increase the consequences of non-compliance, thereby heightening legal and financial risk for employers. So there's an ongoing Senate inquiry as well onto working from home, and that's a report that's due on the 27th of August. And again, through ACCI, we have a voice. In South Australia, we also have the Workplace Protection Personal Violence Act, which I mentioned before. This is an act to protect people from personal violence in the workplace, which came into effect on the 4th of May. It will apply to all workplaces open to the public and enable a range of people, including union officials and health and safety reps, to make application for an order to ban a person who's behaving violently in the workplace. We have concerns about the operation of this Act and are continuing to work with government on this. But today, we're looking at how these matters will impact on you. And to do that, I'm going to hand you over to our senior consultants, Sophie and Andrew, and they will be taking you through this. Welcome, Sophie and Andrew.
Hi everyone, and thank you, Karen, for your introduction. Andrew and I are thrilled to be presenting our Rules of Work presentation to you today. We will start just by looking at an overview of the Employment Law Update. Firstly, we need to look at case law applying law reform changes, which continue to reshape how leaders need to manage workplace obligations. We recommend keeping up to speed with the media for reports on current cases, and also take a look at the Fair Work website to look at those updates as well. Many risks in 2026 are going to be predictable if you keep up to date with what is happening in the employment law world. You can reduce damage to your business by preparing in advance. We say that preparation is key in understanding what your legal obligations are, the risks of breaching them, and how to mitigate those risks. This comes down firstly to awareness. Secondly, being proactive in understanding legal obligations and updates. And lastly, implementing those in the workplace. Prevention is better than a cure, and businesses must put measures in place to avoid fixing mistakes or defending claims from employees. So, the new reality, what are the changes that you may have missed? We'll start by looking at the expanded parental leave obligations. The government funded paid parental leave currently is expanded to 24 weeks or 120 days, and this will change to 26 weeks from the 1st of July 2026, which is the final stage of expansion. Shared time off will increase from 2 weeks to 4 weeks. Parents can take that leave in blocks until the child is 2 years of age. Superannuation is paid on government paid parental leave, and that was introduced on the 1st of July in 2025. Lastly, there was the Fair Work Amendment for Baby Priors Act in 2025. This protection applies where a child is stillborn or dies on or after the 7th of November 2025. The employer can only refuse or cancel the leave because of the stillbirth or death if an exception applies, or if the employee has requested that the leave be cancelled. Employers who breach this protection could face civil penalties. There are, however, 3 exceptions. The first one is the protection doesn't apply if an employer can refuse or cancel employer-funded paid parental leave because of stillbirth or the death of a child under the employee's terms and conditions of employment, such as an employment contract or enterprise agreement. However, this exception doesn't apply if the terms and conditions are varied by the employer after the 7th of November 2025 to allow this. On the other hand, the protection also doesn't apply if the employee isn't entitled to employer-funded paid parental leave because of the stillbirth or death of a child under the terms and conditions of their employment. And again, this doesn't apply if the terms and conditions are varied after the 7th of November 2025 to allow this. The protection doesn't also apply, lastly, if an employee is entitled to other forms of leave related to stillbirth or the death of a child. So let's look at a table comparing government paid parental leave and Fair Work Act entitlement to unpaid time off. We need to consider caregiver terminology. The Fair Work Act and the Paid Parental Leave Act no longer distinguish between primary and secondary caregivers, and recent case law has emphasised that the circumstances in which an employee may be deemed to be a primary caregiver are broader than some employers had previously considered. Employers should be mindful of the ordinary meaning of these terms and consider whether and how they choose to define them, or alternatively, whether they wish to move to a universal approach and remove those terms altogether. You might wish to have a look at our recent article on the full bench of the Fair Work Commission's decision in Metro Tasmania against Australian Rail, Tram and Bus Industry Union. We also need to acknowledge the fluidity of caregiver roles. Where primary and secondary caregiver terminology is retained, employers need to be mindful that these caregiving roles are fluid and that the employee may have an entitlement as a primary and secondary caregiver at different times during their period of parental leave. As discussed in the full bench of the Fair Work Commission's recent decision, that was the Independent Education Union and Peregian Beach Community College, the designation of a caregiver is not a fixed status, and employees may switch between primary and secondary caregiving roles based on evolving circumstances. So let's now look at discrimination and sexual harassment and gender equality changes. From the 1st of April 2026, organisations who have 500 or more employees must commit to and report on 3 gender equality targets over a 3-year cycle. Employers choose from a legislated menu of 19 options that are numeric and action-based. At least one of your 3 chosen targets must be a numerical target. You have 3 years to meet or demonstrate measurable improvement against these targets compared to your baseline data. And consequences of non-compliance and failing to set, meet or improve upon your chosen targets or failing to report data correctly carries severe business risks. And those are, firstly, public naming. Non-compliant organisations can be publicly named by the WGEA. And secondly, there could be procurement bans put in place. Your organisation may become ineligible to tender for lucrative Commonwealth government contracts. We now look at the Australian Human Rights Commission Amendment Cost Protection Act of 2024. It established an equal access model protecting applicants in unlawful discrimination cases from adverse cost orders. If an applicant is unsuccessful, they generally cannot be ordered to pay the respondent's legal costs, removing major financial barriers to pursuing justice. Australia is also experiencing significant reforms regarding non-disclosure agreements in workplace sexual harassment matters. These changes are designed to dismantle the culture of secrecy that historically silenced victim survivors and allowed perpetrators to reoffend. Victoria has led the national reform by passing the Restricting Non-Disclosure Agreements Sexual Harassment at Work Act of 2025, and it ensures that non-disclosure agreements are no longer a standard employer default when settling claims. These specific restrictions build upon the Australian Government's landmark Respect at Work reforms, which establish a positive duty on all employers to proactively eliminate sexual harassment, sexual discrimination and victimisation in their workplaces. The ongoing advocacy from unions, legal centres and victim survivors continues to push other Australian state and territory governments to adopt the Victorian restrictions and further regulate the NDA misuse. All of this is also leading to record damages being awarded against bosses, an example which we'll now cover in the next slide. In this case, Mager versus Khan, a landmark judgment of the Federal Court, a former restaurant supervisor has been awarded $305,000 after being subjected to repeated sexual harassment by a colleague. The court heard that the colleague showed the restaurant supervisor inappropriate videos at work, made intrusive comments about her sex life and asked her extremely personal and suggestive questions. Alongside her sexual harassment claim, the supervisor also alleged she had been subjected to harassment on the grounds of sex, and that was marking the first time the laws requiring employers to manage this form of harassment have been tested. While her claim of harassment on the ground of sex was dismissed, and more on that later, the court confirmed her colleague's behaviour met the legal threshold for workplace sexual harassment under the Sex Discrimination Act. This was also the first case to consider harassment on the grounds of sex provisions. And while the court acknowledged that the workplace culture was rife with crude remarks about women, it ruled that her claim didn't meet the legal threshold because the conduct wasn't directed at her personally. And I quote, "There were some pretty graphic things said, but she wasn't part of the conversation. She overheard it, and none of the comments were about her," said the court. The judge held that in order to make a finding that there had been harassment on the basis of sex, and the relevant conduct, which he accepted was boorish and offensive, needed to relate to her in some way. It didn't necessarily need to be directed at her, but it did need to relate to her. However, the court adds that offensive discussions at work can still create legal liabilities for employers, even if the comments aren't related to a particular person. The court stated there's a new provision relating to a hostile work environment on the basis of sex. He said that wasn't argued here, but if you've got that sort of banter going on, it could be seen as creating a hostile work environment. Conversations like this may also signal a potential risk of sexual harassment, triggering an employer's obligation to take preventative action under their positive duty. The previous record of over $268,000 was set in 2023. In that case, the Federal Court penalised a jewellery store owner for subjecting a young employee to prolonged, unwanted romantic advances and victimising her for making a formal complaint. So now we're going to look at new serious invasion of privacy offence. The new statutory tort introduced into the Privacy Act, Commonwealth Act, commenced on 10th of June 2025. An individual, including employees and contractors, may have a cause of action against another person, such as an employer, where they suffer an invasion of their privacy by an intrusion upon their seclusion and or the misuse of information. The invasion of privacy was intentional or reckless. A person in the plaintiff's position would have had a reasonable expectation of privacy in all the circumstances. the invasion of the privacy was serious, or the public interest in the individual's privacy outweighed any countervailing public interests, such as freedom of expression. An individual does not need to prove any actual damage to succeed in a claim. So, what are the remedies? So, injunctions to restrain further privacy invasions. Damages for emotional distress, non-economic loss are capped at the greater end of $478,550 or the maximum amount in a defamation claim. And correctional orders, formal apologies, or a declaration that a serious invasion occurred. How do we avoid breaches? Review where employee information is being used, by who, in what context, and how is it being documented. Ensure that expectations are set and or the use of data is disclosed or consented to. Conduct training regarding data security, privacy compliance, and appropriate technology usage. And consider the use of employee data to train AI or to be put into an AI model. So, what's coming next in the coming wave of changes? Let's look at working from home. There was the Fair Work Amendment Right to Work from Home Bill in 2025. Around 36% of all employed people reported usually doing some work from home, and of these, about half reported working between 1 and 4 days a week from home. In their submission to the Senate Education and Employment Legislation Committee inquiry into Fair Work amendments, the Productivity Commission submitted that many Australian employers and workers have found a hybrid sweet spot, if you like, when it comes to working from home. The need for legislated right to request to work from home is therefore not clear. And secondly, the Fair Work Commission is currently reviewing the Clark's Award to determine whether and how a work from home term can be included in modern awards. Employers are seeking changes to remove arrangements that cause difficulties or don't apply at home. And unions are seeking for presumed right to work from home and limited and restricted ability for employers to refuse. We'll now have a quick look at Payday Super. From 1st of July 2026, super guarantee payments must be paid to an employee's super fund at the same time as the pay and qualify earnings on payday and received by the super fund within 7 days. There are some exceptions to the 7-day deadline, such as for new employees. And when onboarding new staff, you have 20 days to make their first payment. We've actually got a video at the South Australian Business Chamber on this, so please contact us if you would like to receive a copy. We also have articles with links to the ATO if you would like further information, and those links are very, very helpful. We consider that Payday Super legislation and rules will likely put some pressure on small businesses in terms of cash flow issues, and we will wait to see how that plays out. And we now look at non-compete clauses. So the federal government plans to ban non-compete clauses for employees earning below the high income threshold, which is currently at $183,100, and some contractor agreements by 2027. Government is also considering complementary reforms, including restrictions on non-solicitation clauses, on no poach and wage fixing agreements between businesses, and a one-shot rule prohibiting cascading restraint clauses, allowing only a single formulation of the restraint clause. A legislative requirement for a restraint clause to specify the legitimate business interest and the employer seeks to protect. Non-compete clauses are difficult to defend and
enforce.
And the legitimate business interests can be somewhat vague. So the new non-compete clauses changes will be welcomed, I think. So thank you. And now I'd like to pass on to Andrew.
Thanks,
who's
Sophie.
going to...
Very comprehensive coverage there. So we'll first deal with the legal landmines, the issues that are currently creating risks for employers. First off is flexible work arrangements and agreements, requests. So a flexible work arrangement is a formal agreement under the Fair Work Act between an employee and an employer to change their usual working arrangements as a result of circumstances that apply to them. The circumstances that generally apply are listed in section 65. They're also there on the slide. Probably typically flexible work arrangement patterns will involve changes to the employee's hours, pattern of work, and location of work. The most common example that we see is an employee returning from parental leave who wants to work on a part-time basis while caring for the newborn. An employee is only eligible to make that request and has an entitlement to make the request once they have 12 months service with an employer. That includes regular and systematic casuals only to the extent that they've met that service requirement and have a reasonable expectation of continuing work on that regular and systematic basis. Recently, the Fair Work Act provisions were amended, placing new obligations on employers in relation to dealing with and responding to those types of requests. The amendments also introduced, importantly, an ability for now employees to dispute the refusal of their request, including if a response isn't provided within the required timeframe of 21 days. So in light of those changes, it's critical that employers comply with the new legal obligations and go back and have a look at the sections 65 and 65A, B and C of the Act. That slide there also contains some important information, a summary of the most important bits of information to keep in mind when you receive a request for flexible working arrangements. The refusal can only be on reasonable business grounds. Some examples are there in terms of cost, capacity to accommodate, loss of efficiency and productivity. Quantifications and examples are critical to be able to be articulated by the employer in defending its refusal for a reasonable work request, request for a flexible working arrangement, so that it can be articulated if a dispute is lodged and the Commission needs to arbitrate. As I mentioned, if you fail to respond within the time frame, an employee can also lodge that dispute. So this is an example where the Commission arbitrated a dispute regarding a request. The employee was a part-time employee in Westpac's mortgage operations team with more than 22 years of service. Her duties were highly independent. She managed an eight-member team geographically dispersed across all states, meaning that the majority of the interactions with them were conducted online. After moving house, she requested with Westpac to work permanently from home or a closer local branch to her new home. It was aimed at accommodating school drop-offs and pickups for her two young children. Westpac refused the request, relying on its hybrid working policy, which required staff to attend the corporate office for 2 days per week. Westpac argued that face-to-face interaction was necessary for collaboration and engagement, and it asserted that the wholly remote arrangement would result in a loss in efficiency and productivity and have a negative impact on customer service. The Commission found that Westpac breached the procedural requirements in the Act. The bank did not respond within the 21-day timeframe. It issued a cursory refusal without providing substantive reasons at the time, and it failed to consult or genuinely attempt to reach an agreement. Part of that consultation and genuinely trying to reach an agreement is also to suggest alternative accommodations that can be made. So trying to find a middle ground between refusing and completely accepting the request. It further found the refusal was not based on demonstrable, reasonable business grounds. The team was already highly distributed, and she had successfully performed the role remotely for years, so the bank's argument was not accepted as being valid. The Commission ultimately ordered Westpac to grant the flexible work request and emphasised that employers cannot rely purely on generic return to the office policies to deny these requests. The next issue is wage and super theft. As many people may be aware, there are now increased penalties for employers who intentionally fail to pay wage and superannuation in full when due. The quantum of the penalties is up there. It is a maximum. Intentionally failing also includes unreasonable recklessness, so what some might call intentional blindness. Most businesses don't have to worry about intentional underpayment if they're trying to pay correctly and accidentally get it wrong. But businesses who make no effort and try to claim ignorance will not be protected. The associated financial penalties are in addition to the actual quantum of the underpayment. Where businesses notice that they may be underpaying employees or have underpaid employees, self-disclosure to the Fair Work Ombudsman may provide some safe harbour protection, but there are strings attached. It's quite a detailed topic. It's something that we encourage you to ring and discuss with our business advice hotline. Self-reporting businesses can generally enter into a cooperation agreement with the FWO to avoid criminal prosecution. However, there's still penalties that may apply. There's also a similar compliance code for small businesses to assist with them self-reporting and to provide them some level of safe harbour. As I mentioned, always ensure that you obtain advice if you start noticing an underpayment. There is strategy that goes into reports to the Fair Work Ombudsman. So on this slide, we've got an example of an email that would cause a lot of HR managers anxiety. It's an email from an employee who is querying about their classification level and therefore their pay. Querying about payment for overtime and requesting that a copy of all their pay slips be provided. What should Tim do? First, Tim should meet with the employee and reassure them that they're working through this and taking the inquiry seriously. For both issues, Tim should start by looking at the employment contract to see whether the person is paid sufficiently above the award and the contract contains an appropriate set-off clause. It may be sufficient to satisfy any minimum entitlements and pay that the employee is entitled to receive, both for the classification and for the overtime component. Otherwise, get information from the employee on the duties that they say impact their classification, go to the award or enterprise agreement and start working out whether those duties alter the classification and whether there is any underpayment as a result. In relation to the overtime, check whether there are records. The employee alleges that it was directed and required, so in those sorts of circumstances, if overtime is authorised or directed or required, it will need to be paid. Ask the employee for the particulars on that overtime if it's not readily available. However, businesses should be keeping a record of time and attendance, particularly for things like penalty rates and overtimes, which we'll cover later. In relation to the request for the payslips, the employees are entitled to be provided with a copy of their payslips. It's an employee record, even if it has been emailed to them separately and previously. Then perform an audit and calculate the potential underpayment. That is, what would the person be paid under the applicable instrument, be the award or the enterprise agreement, for the work that they've performed, compare it to what they were actually paid in each pay period. Ensure the communications are regular to keep the employee updated, and obviously do not take adverse action. That would give an arguable basis for a general protections claim because someone has exercised a workplace right or made a query or inquiry in relation to their employment rights. So, as I mentioned before, ensure you keep records of time and attendance, in particular overtime and penalty rates. If there are no records and if there's no reasonable excuse for the records not having been kept, and the employee makes an underpayment claim, the onus is reversed and the employer then needs to disprove the employee's claim. It's a very important fact that catches out a lot of employers. So where do you need to check? Ensure that you check the dot points covered in this slide. When overtime applies, when penalty rates apply, loadings, allowances, those things. And as mentioned there, ensure compliant payslips are issued and that you've got your time and attendance records. So, salaried employees. There are two ways that you can provide a salary to an employee. One is a general annual salary with an offset clause in the contract. The other is to use annualised wage arrangements in modern awards or some modern awards, such as the Clerks Award and the Manufacturing Award. For the annualised wage arrangements, ensure that you comply with all of the procedural and technical requirements set out in those provisions in the awards. For other salaries, it's a matter of ensuring that the employee is paid at least their minimum entitlements in each pay period. So in either situation, you need to have ensured that you have calculated that the employee is paid at least what they would be entitled to be paid under the award for that same work, and again in each pay period. So it is really important to know how much above the minimum entitlements you're paying so that you can calculate an outer limit of extra work, particularly in relation to overtime. Penalty rates and loadings will generally apply for ordinary hours. It should probably form part of the calculation for remuneration in any event, but it's more that overtime hours. So calculate to see how much your salary buys you in terms of that kind of work. Again, it is strictly a pay period by pay period calculation. You can't use overpayments in prior pay periods or overpayments in subsequent pay periods to satisfy that obligation, and we'll cover that in a second. Again, keep time and attendance records for the reasons that I mentioned in the last situation. Wherever an employee is covered by an award or an enterprise agreement, the safe bet is record their start and finish times. So this generally won't apply to award-free employees or employees that are paid above the high income threshold. They do not have a modern award that covers them, and the usual categories of award-free employees will include people like information or IT specialists, HR professionals, accounting, legal department, and managers and executives. The Woolworths and Coles decision. So this caused quite a stir when it came out. It's important to note that it did not change anything. It just confirmed what the legal position has always been. A lot of people thought that it meant that it changed the provisions in relation to how annual salaries worked. It's not the case. As I've said a few times now, just to hopefully drive the point home, it's a pay period by pay period calculation. So Coles and Woolies self-reported underpayments because people were working beyond their rosters and the roster didn't capture the actual working times. They didn't keep the time and attendance records that were required under the Fair Work regulations, and so the onus was reversed and they needed to disprove the employee's claim. So they were unable to do so and instead tried to rely on annual salaries and to argue that the employees were better off overall when looking at their pay for the entire year. The court confirmed that an employee must receive at least their minimum entitlements for work performed in each pay period. This is a function of Section 323 of the Fair Work Act, which requires an employee to be paid in full for work performed at least monthly. When you alter the pay cycle and increase the pay frequency, it then becomes pay period by pay period. Avoiding breaches. So this reiterates what I've been saying over the last couple of slides. So ensure your payroll systems are accurate, ensure you're recording the start and finish times for people who are award or enterprise agreement covered. Ensure that you know how many overtime hours are built into your salary calculations in each pay period. Ensure managers and supervisors are informed and monitor work arrangements to ensure that overtime parameters aren't exceeded. Be clear in policies as to what authorised overtime is. And sometimes it may be reasonable to give instructions to the employees to let them know what the maximum amount of approved or authorised overtime is in each pay period. have a written record of an instruction and direction to them, and anything in addition will then become something that was not authorised and not required, and therefore there's an argument that they're not entitled to payment for that. These are examples of the questions that you should be asking. How do you know your employees are being paid correctly and on time? How do you know if salaried staff are being paid at a high enough rate in each pay period? Do my contracts have a properly drafted set-off clause? If the FWO investigates, can I demonstrate that I've done my due diligence? If you can't answer these questions, then you may have some fairly significant compliance risks. Rosters and public holidays. So this was another decision that caused a bit of a stir. BHP assigned employees to work on public holidays by drawing names out of a hat. This was held by the court to be a breach of Section 114 of the Act, which allows employees to request that an employee work on a public holiday. Employees, as a default, are entitled to be absent from work on public holidays, and employers have a right to reasonably request that they work. However, the employee can reasonably refuse. So it was found that the practice that BHP implemented didn't allow the employees to in fact refuse. There was no request that was being made, and so it was a breach. BHP was ordered to pay $84,000 in compensation as a result. So these are the lessons to take away from that decision. Employers have to make a request to work public holidays. Posting a roster does not qualify as a request. And remember that even if requested, employees can reasonably refuse for the reasons that are set out in Section 114 of the Act. So ensure you're familiar with Section 114, revisit it, make sure that it makes sense to you, and make sure that all your supervisors and managers are across those requirements. Personally, I don't think contracts can circumvent this, because contracts cannot be less generous than the National Employment Standards, which is where this provision sits within the legislation. I think it would be arguable that if there was a blanket consent in the employment contract or a blanket agreement by employees to work public holidays, that would not strictly comply with the requirements of Section 114 either. Lastly, AI-driven claims. So AI has made it far easier for people to draft and make claims in the Fair Work Commission. It's unfair dismissals and general protections claims. It has led to a surge. Such a surge that the Deputy President Coleman, in a recent decision, noted that there was no effective disincentives for speculative claims. And so they come in great numbers, compounding the Commission's caseload. Ultimately, the filing fee of $89.70 is not a deterrent. And in fact, almost 40% of applicants apparently suffer such financial hardship that they're unable to afford the $90 filing fee. So we hope and have our fingers crossed that there might be some reform in this area to stop speculative and unmeritorious claims being made, to stop legitimately dismissed employees from, as I say, shaking the tree on the way out to see if anything will fall out. It's difficult for employers because it means that they still need to go to the cost of defending and probably engaging some representation to defend these types of claims. And for commercial reasons, more often than not, it makes sense to pay the applicant some go-away money rather than spending more money to defend an unmeritorious claim. It's just the harsh reality of that jurisdiction. So as noted in the slide, there has been also a rise in AI-driven applications from people seeking jobs or job applicants. Similarly, AI has also been used in the recruitment processes. So the AHRC has just given businesses a bit of a warning to be on the lookout for the risk of algorithmic discrimination. So breaches of general protections claims, because discrimination applies to prospective employees as well, and they're able to make such claims. And just make sure that your AI isn't algorithmically discriminating against people, unlawfully, of course. And finally, use of AI in the workplace. This decision centred on whether an employee was dismissed. So the employee in this case was a permanent full-time legal assistant in Perth. He started work in January 2023. The relationship subsequently deteriorated and the employment ended in March 2024. Before termination, the employer had concerns regarding attendance, performance, unreliability, and other patterns in terms of the work. On 6 and 7 March, the employee was absent due to a migraine. Both mornings he texted to notify his manager, but because he had exhausted personal leave on the 7th of March, he applied for annual leave. He did provide medical certificates for both days, however. Unfortunately, another director, frustrated, used ChatGPT to send a termination letter for abandonment. The termination was alleged to be immediate. So the employee lodged a general protections claim. The employer argued that the employee wasn't in fact terminated on the 7th of March and that his employment continued until the 20th of March, at which point it ended by reason of his abandonment and not at the employer's initiative. Now, the Fair Work Commission was not convinced. It said that the AI drafted text or letter sent to the employee clearly terminated the employment relationship immediately, and that caused the Commission to uphold the employee's application. So just beware in jumping to use AI for things. I think probably the bigger takeaway there is follow a proper process. And unfortunately, actually, abandonment is a very technical area of law. And you're probably, if someone doesn't rock up for work but tells you that they haven't resigned and will come back, probably the better way to go is through the misconduct for not attending. But again, for those tricky areas, call us and speak to the business advice line in the first instance.
Thank you, Andrew and Sophie. That was a great wrap on what to expect for the rest of 2026. We will be back with 3 more webinars before the end of this financial year, and then we will be having some monthly ones. So if there's topics you'd like to hear about, please contact us. Just a little bit of information about us. Our services, how South Australian Business Chamber can help. Our services include industrial relations advice, support and representation. We've got a business advice hotline, which I mentioned earlier, where Philip and Madeline are available to speak to members. We've got advice available on employment contracts and policy reviews, payroll compliance audits. We can help you with workplace health and safety and workplace relations training and management courses. We provide webinars, when, as I said, they will be monthly as of the next financial year. IR briefings for regional businesses. We are looking forward to catching up with the regional businesses in the next year. And we've got briefings for executive and management. Please subscribe to the SA Business News. Sophie, Andrew, myself, and the rest of the policy team all write articles for the SABN, and they are articles that are worth clicking onto and reading. So when the SABN comes into your email box, please click on it. Please call our advice hotline if you're a member, or if you're not a member and are interested in becoming a member, call that number. And please, if you have any queries, contact the policy email address on policy@sabusinesschamber.com.au with any queries you have about what might be coming up. So thank you very much.